Welcome everyone to 4IP Council's webinar, Artificial Intelligence and Copyright in the Creative Industries. My name is Axel Farazzini. I'm the Managing Director of 4IP Council, and I will be your host today. Next slide. Seems there is. Okay. As you may know, 4IP Council is a not-for-profit research organization focused on the link between IP and innovation. To identify the most relevant topics and produce empirical research, we work closely with a wide variety of academics, experts, IP organizations, and stakeholders. On our website, you can find a range of free materials, studies, guidelines, case law summaries, recordings of our webinars, like the one of today. Moreover, we produce easy to digest content, especially tailored for non-IP experts, SMEs, startups. This is free of charge, of course, and some examples are interactive graphics, interviews to inspire the startups and anyone willing to learn more about intellectual property benefits. With this, we aim to assist innovative startups and SMEs to learn how to use IP to grow their business. As you know, more and more things are increasingly connected thanks to the Internet of Things, and to achieve this, standardized technologies are needed, often protected by patents. This is why we have created a case law area with summaries of court cases regarding standard essential patents. And this section is now also available in Chinese and Japanese. We have also created a dedicated Chinese part of the website where we post articles and summaries. And we have just published a new infographic, as you can see at the top left of the screen, a new infographic to help startups and SMEs to use trade secrets. So I invite you to check it out. Now, let's start with the most important part of today, because without further delay, it is my pleasure to have Dr. Hailey Bosher as a speaker in this webinar. Dr. Hailey Bosher is an internationally published legal academic, speaker, and legal consultant specializing in intellectual property, media, and entertainment law. She is senior lecturer and associate dean at Brunel University, London, visiting research fellow at the Center for Intellectual Property, Policy and Management, blogger for the specialist IP blog, the IP Cat, that I believe you all know, deputy editor of the European Trademark Report, and founder of the World IP Women Network. A final remark for the audience. Please do not hesitate to use the Q&A tool to submit your live questions during the presentation. You can find it at the lower part of the screen. You can raise questions anytime during and after the presentation. We will take them right after the presentation, okay? And without further ado, Hailey, the floor is yours.
Thank you very much. And I'm just going to put my timer on because I definitely have a reputation for talking a lot. Thank you for having me, and welcome everyone joining this talk today on artificial intelligence in the creative industries. In particular, I'm looking at it from a copyright perspective. So very exciting topic, which I like talking about. So hopefully it will be interesting for you. And yes, please put any questions in the chat box throughout, and then we will have time for questions at the end. I'm going to try and only talk for half an hour. Let's see. So artificial intelligence, probably we all know or have some idea at least of what it is, although interestingly, there is no agreed definition. And I'm not going to talk for a long time about the definition of AI, only that we are all on the same page with the kind of technologies that I'm talking about. And I'm going to give lots of examples of how AI is being seen, already being used in the creative industries. And we're going to talk about the impact of that in the way that the industries are using AI in content creation or analyzing data, like how it's useful. And then, as I said, in the context of what that means for copyright regulation, and look a little bit about what's going on in that area. Because with law, it always has to update for new technologies. And this is a new technology that was emerging technology that we're seeing develop. And so we can start asking really important questions about whether we think that the law needs to be updated or it can apply already as it is to the new technology. So that's kind of the setting the scene of what we're going to be talking about for the next half an hour. So, as I said, there's no agreed definition of what AI is, I think partly because it is emerging and developing all the time. So you don't want to set on a specific definition and then it moves forward and actually it does something else. I've given two examples here. One is from the UK government industrial strategy, where they say that it's a technology that can perform a task that would otherwise require human intelligence, such as speech recognition, language translation, and then kind of like an academic definition, which talks about the technical side of it, meaning that it embodies sets of codes, techniques, algorithms, and data that enables a computer system to develop and emulate human-like behavior. What I find really interesting about discussions and definitions of AI is this constant parallel and metaphorical understanding of AI as being something human or doing something that humans could otherwise be doing. And I think that is the reason why we see a lot of fear around, like, is AI going to ruin all our jobs and take away the human element? So it's really interesting. We don't see this with a lot of other technologies. Like when they invented the photocopier, it wasn't like all of a sudden like, oh no, what do humans do now? It's really a unique technology development that we are talking about it in relation to human-like behavior. But as we will see from the examples, at the moment, AI is not replicating human behavior. It's much more limited currently. There is potential that it might be able to develop and do more things that are more human-like. But at the moment, we're seeing that the capabilities of AI are not quite there. So when we're thinking about copyright protects creative outputs such as books, film, theatre, music, broadcasts, photographs, images, designs. And so that's the context I'm thinking about, that kind of creativity. And so the question is, do we think AI can create? And does it create something that engages with copyright law? So I've put two questions here. Can AI create? I think AI can do things, make things. So in a sense, it creates something. There's usually an output. We put in some data, it does some magical stuff in the middle, and then it outputs something. So it creates something. And you can see here, it says AI can see, hear, speak, move, and write. Again, really human words that we're using to describe what AI can do. And in that sense, it can create something. But a different question, which I think is much harder to answer, and there's big debate around this, is whether AI is capable of creativity. Because it relies heavily on the data that is input and it follows patterns. Whereas the concept of creativity is something that is usually more original and draws on a bigger range of data if you're trying to talk about humans in relation as if it was an AI. But it's a really philosophical question, right? It's not actually that straightforward. Just like we don't have a definition for AI, we also don't have a definition for what actually is creativity. There's lots of really interesting literature and data and research around like what the creative mind looks like. They put people like in an MRI scanner and look at their brain while they're playing music to see what happens. But we don't really know you can't define creativity. It's very elusive. But some really interesting kind of ways to think about creativity. I put some quotes here. Creativity is not just about what you create, but why you create it. And that really links it to like human emotion, human motivation, human experience. It also says about creators draw on a lifetime of experience. So it's not just the input data equivalent, like, oh, I'm going to listen to these 5 songs and then I'm going to create a new song in the style of those 5 songs. It's also the lifetime of the creator, like the skills that they have, the experiences that they've had. And it's much more of a complex kind of process, we would say, but what is creativity? So my view is that AI can create, and it can detect patterns, and it can take the input data and it can make something that you might consider original in the sense that it's exactly different to the things that were put in. But whether it can be creative, I don't know, because I think that the concept of creativity is something inherently human. But lots of people would disagree with me. This is not undisputed, shall we say, and especially probably people who are developing AI and know a lot more about the technology than I do. They might argue that AI can be creative and can make something original, but it also depends on your view of human creativity as well. Like if you think that human creativity is just about taking everything that you know, like all the songs you've listened to before, all the books you've read before, and then churning out a new version of that. If you think that's what it is, what creation is, like human creativity, then you probably can convince that AI can do that. But if you have a broader concept of creativity and you think that it's more about kind of it's more philosophical and it's also comes from within the person and you can't nail it down as easily, then maybe you could say AI is never going to be able to emulate human creativity. But this is really important when we're thinking about copyright, because if AI can be creative and can create something that is original in the copyright definition of originality, then it could potentially be creating something that is copyright protected. Also, copyright protects some unoriginal work. So when I say original, I'm going to explain a little bit more later, but originality in copyright is not necessarily how we use that word in everyday language. And broadcasts and sound recordings are unoriginal protected copyright content, because if you think about it, a sound recording is the fixation of a musical work, and the musical work is the original, and the sound recording is then already immediately a copy of that. So it can't be original, it's already technically a copy, but it still can't be copied from another sound recording. So these are the kind of copyright, when we apply copyright to this context of AI creation, these are the kind of questions that we're asking. There's this really interesting study about what creators are, the perception of creators around AI. As I said at the beginning, some people, there is a fear that AI is going to replace human activity or devalue it. But this 2018 study was really interesting. It said that most creators see AI more as a potential assistant to help with their workload and an enabler to help them deliver their creativity, rather than something that will replace their creativity. And most of the creators in the study didn't actually fear that they would be replaced by AI, as much as they were more worried about their work being devalued, because AI might be able to produce like more content at a cheaper price, for instance, than the human created version. So again, going back to the concept of like creativity and inspiration, in the study, we also saw highlighted that the creators believed that inspiration comes from anywhere and everywhere, whereas AI is restricted to the available data, and therefore it is not able to create at the same level as a human, because it can't have that element of randomness or serendipity. And I just, this table, I don't know, graph table, you can see from on the slide, is from the study, where it's showing how AI can be, and technologies can be used as a tool to enhance creativity, but not their view is also that it's not necessarily going to replace it. So let's look at some examples of how AI is being currently used in the creative industry. At the minute, we are seeing AI being used for content creation, whether that is, I'll give some examples in a minute, like you can question the quality of them or not, but it is helping to create content, or you could argue is creating content. Also content enhancement and post-production workflows. It's being used to, as I said, analyze data, extract data, basically enhancing processes. For example, in improving digital archives, all that kind of very data heavy, process heavy uses of arts and culture, like in libraries and archives, but also in the actual creation of content. And we're seeing it applied in industries involving audio, image, video, gaming, journalism, scriptwriting, filmmaking, social media, and marketing. So a lot of areas are using AI in the creative industries, and we're seeing it in these main ways. So I'm going to give you some examples of AI writing a script. So this first one is, you can tell if you know Harry Potter. The input data into the AI was all the Harry Potter books, and then they tried to get the AI to write a chapter that could have been in Harry Potter. And you can see that the AI struggles with narrative. So although it can produce a chapter, it doesn't have a lot of coherence. It's got the right characters. It's sort of Ron was standing there and doing a kind of frenzied tap dance. He saw Harry and immediately began to eat Hermione's family. So it's like, doesn't make any logical sense. I think this is the kind of thing where we can talk about, this is where AI is at right now, and perhaps in the future it will be able to be more, have more comprehension. But narrative and storytelling, again, you could argue is very much a human endeavor, especially for the time being. Things that AI is maybe better at in terms of the current abilities of the technology is producing art and image generation. So probably you've heard of the next Rembrandt, which is this image here that you can see, a 3D printed painting made from all of the other artwork made by the same artist, and then curated. The algorithm used deep learning algorithms and facial recognition techniques to produce what could have been the next one. And there are studies where they've done this kind of content creation by AI and by humans, and then tested, and the participants couldn't tell the difference between the two, and that was around artwork. So in some areas, I think AI is able to produce more convincing content. There's an example. AI is also being used in news, which I don't know if you would count that as the creative industries. Some people would. For example, the BBC use an AI-based system to perform, like basically to make a summary video. Like it chooses the shots and the framing and the sequences for a video, but actually, again, the initial results were quite limited. And I think with things like news, it's about the AI understanding the importance of certain bits of information, but also creating that narrative. Like, we think news is just factual, but actually there is a storytelling element to it. So in the music industry in particular, these are some just more examples. We're seeing the streaming services obviously use AI to enhance the user experience. We've got AI being used in the creative process, so as tools to assist in the creation of songs. I put the example, the fifth example is Warner signed Endel, which is an algorithm that creates tailor-made custom sound frequencies, which is an interesting way to describe it. It doesn't say songs, but anyway, although it was a bit of a headline, it was a bit of a buzzword, if you like, because they did sign Endel for 20 albums, but really there were a lot of people behind that. And when they registered the copyright for the songs, it was the engineers. They put people, not Endel. So sometimes there's a bit of hype around the extent of what AI is doing, and when really there is a lot of human engagement. So I just wanted to play you an example of this isn't one by Endel, but it's the same kind of music where this is what it sounds like when the AI is creating like soundscapes. Hopefully you can hear this. So that's the kind of music that AI is able to create. And it is being utilized in things like that kind of background music or mood music. Usually something without lyrics, and I'll give you a lyrical example later and you can decide why. And again, it's about that lack of narrative and emotion. This is really although they would argue that they're creating that for a mood, but that, based on that data. So that's where we're at with where AI is being used in the creative industries, and the kind of limitations that we're seeing in terms of what the technology is actually capable of doing, and how we're seeing the creators respond in terms of their perceptions of the uses of AI. So with copyright, we've got two main questions that have come up with this development of this technology. The first one is the work created by AI actually copyright protectable? And if so, who owns it? And then the second key question is whether there is copyright infringement when we are using copyright protected works as the input data to the AI, and also the content that's produced at the other end from the AI. Does that infringe? Do you see? So the use of the AI, the use of the data in the AI, and then also the actual content that's produced at the end, whether there's a copyright infringement there. So I'm just going to use the last 10 to 12 minutes to try to get you to start thinking about these questions. But there actually isn't an answer, because the law is not clear on either of these points, and there is consultations happening at international, European, and national level in lots of countries, where they are doing exactly this, thinking about what is AI doing and how that engages with these questions, and do we need to legislate and change the law or policy to address this new technology in the realm of copyright. So I'm going to give you my views and what's going on, and raise the questions, but there's more questions than answers, because the law, it's not decided yet. It's all up for grabs. So if you're interested in this and you have views, then you can absolutely get involved in the consultation process, as I said, international or national level. So first of all, copyright ownership. So obviously, in order to own it, copyright has to apply to the thing that the AI has created in the first place. And assuming that it does, then who is the owner? We have several possibilities that it could be. Usually, when copyright content is created, it is initially owned by the creator. But there are some instances where that's not actually the case. So for instance, when I create something in the course of employment, actually it belongs to my employer. When I create a sound recording, it's usually owned by the producer, which is the person who makes the arrangements for the song to be produced. So there are these like nuances in copyright law about who owns the copyright, but it does usually start with the creator. And so when you're thinking about that in an AI context, you're like, right, well, who's the actual creator? Is it the engineer, the person who created the AI? Is it the AI? Is it the funder of the AI, which would be the equivalent of like the producer in a sound recording situation? Or is it everybody jointly together? Perhaps there can be more than one copyright owner. So the test for copyright subsistence, as I mentioned, is that for certain types of works, the work has to be original. But the meaning of the word original in copyright law is not that it is necessarily the same in everyday language. So under UK law, we say that it requires skill, labor, and judgment. and under EU law, its own intellectual creation. It's a very lofty term. It's very hard to pin down and be like, what's original and what's not original. But it's a relatively low threshold. You just have to do you have to make your own creative choices, and you have to, it has to not be copied. It's not the same as like for a patent, for instance, where you have to take the next inventive step, or for a trademark, it's a monopoly, so it cannot be the similar to everybody else's. Whereas in copyright, two people can create something that's very similar, but as long as they didn't copy each other, then they can still have copyright in both of their creations. So if I stand next to you and we both take a photo of the same scenery, they're going to look they're going to look exactly the same, but it's still my own intellectual creation. It's your own intellectual creation, as long as we didn't copy each other. So it's a low bar. And as I said, some copyright protected materials actually doesn't need to be original at all, like a sound recording. So I think that AI probably could reach these thresholds. Depends on when you get into the own intellectual creation part, because and a really simple AI algorithm is just taking the data, sort of like churning it up, but it makes decisions and then it produces something else. And as I said, it is a low bar. But then again, it goes back to that question of like, what do you think creativity actually is? Do you think that every time I create something, I really am just churning out what I already know? Like every word if I write a book, I'm using every word that I've ever learned from anything else I've ever written. Or is there something more to human creativity? Like, do I bring something original just by being me and putting my personal stamp on the thing that I've created? So ownership, as I said, let's say that for the sake of argument, AI creates something that is copyright protectable. As I said, who owns it is the next question. Could be the creator, which might be the AI. And once you have the reason why it's important, why do we care if AI can own the copyright or not, is because once you have copyright ownership, then you have the rights to that thing that you've created. You can license it, you can assign it, you can make money from it, you can grant people permission to use it, or you can deny people permission to use it. For a human creator, copyright is really important for being remunerated for your creativity and controlling where and when and how your work is used. Copyright lasts for generally 70 years after the death of the creator, so it can be inherited through a will. And as I said, there are situations where ownership is the creator. Sometimes it is the employer, whereas if it's a freelancer, usually the freelancer owns it. There's all these different kind of like legal nuances. But everything is subject to contract. So we can decide, I can talk to my employer and negotiate that actually everything I create belongs to me and not them. Copyright is managed through contracts. So you've got all the copyright laws here, and then on top, pretty much most of the clauses we can decide you can negotiate and contract in and out of. Not all of them, but some of them. So I'm going to give you an example. Maybe you know this case. This is the monkey selfie case. And the reason why we draw on this discussion is because it's a non-human creator. And although it's not a machine, it's a non-human creator. So we can think about how the courts looked at this case. This is an example of, I don't know, maybe you know. David Slater was a UK photographer who he set up his camera and gave the camera to this monkey here, and then the monkey took the picture. And as I was saying, when we question who is the creator, normally it would be the photographer. And in this instance, the photographer was actually the monkey. But then there were also arguments that David Slater set up the camera, he edited the picture, it was his idea, all of this stuff. And obviously, up until this point, no monkeys had ever had copyright before. It also has a philosophical clash because, as I said, the whole point and justification for giving copyright is to remunerate the creator and benefit society as a whole with creativity and culture. And do we need to motivate non-human creators to create? So that goes for monkeys and AI. In this particular case, it was in America, this case, and it went back and forth a lot. There were lots of people arguing different sides, like the zoo that owned the monkey. They were like, maybe we have copyright. the Wikipedia basically said that it should be in the public domain and freely available for everyone to use because a monkey can't have copyright. And actually, annoyingly, in the end, the case settled out of court. So there's no legal ruling on whether the monkey could. But for some of the hearings, the courts did state that copyright needs to be owned by a human. In America, as you know, law is different in different countries, so that doesn't necessarily mean that it would have been the same answer everywhere. But I imagine, for instance, in the UK, it would have been. So to the extent that copyright can be owned by an animal, the answer is probably no. And I don't know that it's much of a stretch to go from that to can the AI own the content that it's produced. So that at least narrows us down to maybe the designer of the algorithm or the funder. The idea of joint authorship is also quite interesting because there are different players in the game and contributing stakeholders. Under UK law, we have this test for joint authorship that involves things such as do the parties have an authorial contribution to the output of the content? And you could argue that the funder, for instance, does not, but also it requires that the collaboration, so the first part of the test, is that both people know that they're collaborating on the same kind of overall output, and whether the AI is like explicitly like knowing that it's collaborating with the humans. It's maybe a bit kind of like utopian futuristic views, I don't know, but anyway, that is an option. So as I said, this is being reviewed at national and international levels, so I just want to give you some examples of what's being looked at. Under the UK law, we do have this section 9.3 of the Copyright Designs and Patents Act that does say that in the case of a literary, dramatic, or music or artistic work which is computer generated, the author will be the person by whom the arrangements necessary for the creation of the work are undertaken. So that's really similar to what I said about who owns the sound recording. However, in the consultation, we're seeing that this definition, which was created a long time ago, it wasn't written for AI. They're just trying to see if they can apply that law to the situation of AI. Has basically three limitations. From a legal perspective, people are arguing in the consultation process that the law is unclear and contradictory because it requires there needs to be this like human author, human characteristics such as personality, judgment, and skill in the copyright law. So like, why are we giving copyright to computer generated works? There's the economic limitations. As I said, it's about that links to the justifications of why we're giving copyright. Like, does the computer need to be rewarded for the content that it created? And then there's also philosophical arguments that copyright has its roots in human creativity and should only apply, therefore, to human creators. So I'm realizing I'm getting close to time, so I'm gonna this slides will be available. I'm not gonna read the whole quote, but as I said, there's also consultation going at international levels, such as the World Intellectual Property Organization, and this is just a quote giving you some kind of insight into the kind of arguments and discussion that's going on. And as I said, it is a discussion, it is up for debate, there hasn't been any decisions made, and it's a really interesting time to engage in this discussion. So just to finish off, this one's a bit more straightforward. Whether there has been copyright infringement or not, when the materials used in the data by the AI and also the content created at the end. So copyright protects. Once you have copyright in your work, you have the right to stop others from copying. And so basically the main type of copyright infringement is copying. But you can also infringe someone's copyright by communicating it to the public, by editing or adapting that work. I've put here for the UK Section 17 is infringement of copyright by reproduction, and just some details of like what the law says about that is quite broad. It can be in any material form, including storing the work by any medium by electronic means. Copyright infringement can be deliberate, innocent, or subconscious. So under that definition, I think that the use of the AI data, if the content that was taken was protected by copyright, then it probably would need a license, otherwise it would be infringement. In terms of the work that's produced on the other side of the AI, so the content that's created, we need to look at this thing called substantial part, because copyright infringement is taking the whole of or a substantial part of the copyright protected work, unless there's an exception. So when you put the data in, I imagine that's the whole of the work, so we don't really question that. When you have the content that comes out the other side, the question is whether that takes a substantial part of any of the data that went in. Substantial doesn't mean amount, it's quality, not quantity. It's quality, not quantity. Yeah, I always have to check I'm saying that right. It's about whether the parts taken are the original parts or the unoriginal commonplace elements. And so that would be totally dependent on the case, on the specific example. It's not something that we could say like AI does or doesn't infringe copyright with the content produced. It would depend on what the content produced looks like. I'm just going to give you an example here. So this is an AI producing a song in the style of the Beatles. So all of the content that went in were whole Beatles songs. So you can imagine that would require a license. And then you can decide when you hear this song whether you think that this is a substantial part of a Beatles song. Let me see, hopefully you can hear this. Not going to play much more just because we're nearly at time. So again, with the lyrics, the narrative doesn't make sense, which is interesting. But luckily, in this instance, this was created by Sony, and they are the copyright holders of the Beatles catalogue, and therefore there was no actual infringement. But had they not been, I think that we might have, definitely with the input data, with the out content, I mean, you have to point to the work that it's infringing. So they can't say like this infringes the whole of the Beatles catalogue. You'd have to be like, this song infringes and takes a substantial part of Eleanor Rigby, and then point to the parts of the song that takes a substantial part. So it wouldn't actually be that straightforward. It's potential. And as I said, depends on the circumstances, but it's not that clear. So again, this is something being discussed at UK national and international level. I think copyright holders are arguing that you need a license because obviously they don't want their content being used without a license. That's kind of not a surprise that that's their view. And actually, I would probably agree with them. But the developers of AI are arguing that they should have an exception and be able to use content for the development of the AI technology, which, you know, is also an understandable argument in the sense that it will restrict their ability to experiment and trial and error, you know, try to develop this technology to see how far it can go if they are limited by the fact that they need a license for the use of the material. There's no clear license structure that currently exists, or other than like the general get a copyright license, go to every individual copyright holder and ask them how much it costs. You know, it's not very easy. And their argument would also be that you don't even know necessarily what data goes in. It's like, you could just produce, like with something like the Beatles thing, it's kind of obvious, but you would have to like reverse engineer the output thing in order to figure out what went in. Anyway, again, this is at the UK level. We're seeing a lot of metaphorical discussion about the human brain and whether this kind of copying with the input data is what humans do anyway when we create something new. So when I'm saying like the input data is copied because you take the whole of it and then the algorithm churns it up and puts out a content, the argument for it not needing a license for that is that I don't need a license for every book that I've read when I write my own story. So very interesting human-based arguments. And again, the same questions are being asked at international level, such as I just mentioned, the fear of liability for people who are trying to research and develop AI. So they're really arguing for a copyright exception. And so just to conclude, I think that we're seeing the development of AI, and it's definitely impacting the creative industries, but creators are seeing it more as a tool assisting their creativity than necessarily something that can emulate human creativity. But not everybody would agree, and maybe that's just where we're at now. Maybe in the future things will be different. Some copyright laws maybe can be applied to AI use of copyright content and AI production of copyright content, but there's lots of different views from different stakeholders about whether that's appropriate. And as I said, we really don't know the answer of what will happen in the end, because everything's currently up for debate and under consultation. So it's really important, if you are working in this area, to engage with those discussions and get involved with the consultations, because you will have your own experience and you will have your own kind of perspective. And everybody, like I said, there's a range of perspectives and there's a range of arguments. So I think it's really important to engage where you can. And I will stop talking now. I don't even know how far I've gone over, but thank you so much for listening to me. You can find me online. This is a book that I recently published, and Whose Song Is It Anyway is a music copyright podcast, which I work on. So thank you very much. Any questions?
Thank you so much, Hayley. That's been very, very interesting, and I highly recommend actually your book. I loved it. I'm not sure I understood everything, but I loved it. Let's start with a simple question that we received. We received many questions related to NFTs. Okay, so that will be after. But on slide 10, you talked about a study, and one person is asking, could you provide more details about this study? So, hold on.
Oh yeah, that's it. I was just going to go back and find it, but what I will do is I can put the link when 4IP put all of this on your website. We'll put the link to the study so you can access it.
Okay, great. Thank
This
you.
one, yeah.
Yeah, that's it.
It's commissioned by Adobe, I think.
Okay. Then, should we make copyright law that specifically addresses AI technology?
So this is an interesting question, because in copyright, as I said at the beginning, we always try to keep up with technology, and you'll see, if you look at like the history and evolution of copyright law, it always changes when we have new technology. And that happens if with smaller things, like when they invented the photocopier or the camera, and then the internet. Like every time there's a new technology, copyright law evolves. But also we have to be so careful not to make law too technologically specific. So I don't think it's a good idea to put in the law, and you don't see it, right? We don't see like this law applies to a photocopier, but you have to make it broad enough that the law can stand the test of time for as long as possible. So I don't think that we should make law that specifically regulates a type of AI technology, especially because it's being developed so fast. And so it would, by the time the law is implemented, it might not even apply to AI anymore because of the way that AI is defined. We have to be really careful in copyright law to be technologically neutral as far as is possible. At the same time, I do think that we should update the law because there's a lack of clarity around what you can and can't do with AI. Is it infringement? Is it not? Like, I'm arguing that in certain circumstances it is, and in certain circumstances it's not. And that can be really difficult for a startup or some people working in AI, because they don't know if what they're doing is allowed or not, or if they need a license or not. And that's not good. The law needs to be clear about what you can and can't do.
Okay, very good. Simple question, but I'm not sure the answer is that simple. Can we say that an AI creation is a computer program?
So in law, this is the thing, right? So the computer generated works, in law, the way that we define things is not the same as we would necessarily use it in everyday language or in that sector. So probably if you are an AI engineer, you might turn up your nose and be like, absolutely not, this is completely different. But it's the same, as I said, with the word originality, the way that we might use it. Even the word originality is different in patents and trademarks than it is in copyright. We define the scope of the word that we mean in law. And law is human made. Sorry to go back to human analysis, but like we decide what the law says and we decide what it means. So we could decide that AI comes under the heading of computer programs and then apply all of the computer programs related law to AI if we wanted to. You might find that some of it's appropriate and some of it's not. So therefore there might need to be like a nuance. And that's why sometimes law looks really incoherent because there's so many kind of exceptions and limitations and nuances, but that's usually because of this kind of thing where you want to decide the scope of the law where it doesn't and doesn't apply. It's actually like the language of the law is really complex for that reason. You can't usually write it in everyday language because the everyday language is too ambiguous, and we need to be really specific about what we do and don't want to regulate. So yeah, I think AI could come under the heading of, under the UK law, this computer generated works, but it's about deciding whether we want it to or not. It's a conscious decision rather than just assuming that it would, and then looking at like how that would impact the creative industries and like, do we want to grant rights the same? Like, for instance, some copyright lasts 70 years after the death of the creator, and some copyright lasts 50 years after the thing was created. So you could argue, for instance, that AI produced work is protectable by copyright, but because there's no human creator, actually we only want to protect it with 50 years of copyright. We don't want to do 70 years after the death of the creator because also there's no death of the AI. So it's about decision making and consciously making that decision and thinking about the impact of where the scope of the law begins and ends.
Okay, so something that is in the same line, which is regarding for the film industry. Okay, how will AI affect actors in the film industry if actors are computer-generated images and don't perform physically on the set? So this person gives an example, bringing back Marilyn Monroe, or even an actor who is alive, like Leonardo DiCaprio, to perform digitally. Will AI lessen performance rights and limit it to only dubbing rights?
Yeah, it's a really interesting question. And also I didn't talk about deepfakes because some of it's not actually AI that does that, but even just broadly speaking, this kind of technology interacts with copyright, moral rights, personality rights, depending on which country you're in. And again, it's about potentially updating the law to protect the actors. It's again, copyright is all about balancing the rights of the different stakeholders. If we want to, we can give the rights to the actors and say, no one is allowed to make a computer generated version of you without paying you. We can decide that. Like, that's how copyright works. If we think that that's appropriate under the justifications of why we give copyright or not. I think so. I think absolutely you should. Just because it's a digital version of you, people only know the digital version of you based on the real version of you. And I think that under US personality rights, that would apply. Under UK, we don't have personality rights, but we have this thing called passing off. So there was a case where Topshop, this clothing brand, put a picture of Rihanna's face on a t-shirt, and then she sued them successfully for passing off because people would assume that Topshop had asked her permission and they hadn't. And it would be the same thing. If I'm watching a film and I see Leonardo DiCaprio, whether it's a digital version or not, I'm going to assume that he was fine with that. And they had paid him, maybe like, there was a license or something. So it could potentially fall under these laws. But again, everything is up for grabs in terms of it's not been decided. I think that for, like going back to that study here where it's saying that they creators are worried about AI devaluing their creativity and their skills, we can protect against that with stronger regulation and stronger rights for creators if we choose to.
Just to make sure, what about if the actor is dead for more than 70 years in this case? Creating a deep fake of a dead actor.
So this is a really good question, and it depends on the country, because for some countries, your moral rights, for example, last forever. And in other countries, like in the UK, the moral rights only last as long as the copyright. So, there's this Samuel Beckett example where Waiting for Godot in can't be performed by actresses in countries such as France because he didn't approve that adaptation of it. Whereas we could do that in England without infringing the moral rights because the moral rights have expired in this country. So again, it depends. It depends on the country, depends on the rules, and these are the kind of things that we should be asking. Like, do we need to update these rules because we have AI? Because these rules were made when AI didn't exist, and you couldn't just bring someone back from the dead 100 years after they had died. So we have to decide whether we think that's appropriate or not, or whether we want to balance that with freedom of creativity. And there could be a lot of benefits of being able to, I would argue that there's a benefit to being able to perform Waiting for Godot with female actresses. And you can do that here, but you can't do that in France. So I think that you have to balance the creativity and culture development as much as the AI development as against the rights of the creator.
Okay, quick follow-up. Should we have an internationally harmonized law for AI and copyright then?
That links really nicely, right? Because I was just saying you can do this in France, but you can do this in England, but you can't do this in France. So some people would argue that we should make one law and put it for everyone, and we should make it international. And we do have international minimum standards for intellectual property, and copyright is also one of them. And that's just the absolute bare minimum that a country can do. And then you can have all these nuances. But creativity is so connected with culture. It's, I think, also very important that each country is able to make their own decisions about what their law looks like. Having international minimum standards makes it easier to trade. So it's easier to license your production worldwide when we are all doing this minimum standard. So there are pros to that, but there are also cons. Like, for instance, in some countries where copyright, so we have these things called copyright exceptions where you don't need permission from the rights holder. And different countries have a different set of permissions. So in some countries where music is used a lot in worship, then there's a copyright exception where if you are using music for worship, for the purpose of worship, you don't need permission from the rights holder, because that's really important to that particular country's culture. In the UK, for instance, we don't have that exception. If you want to use copyright material songs for the purpose of worship, you need a license. So copyright will always reflect the culture of that country. And so I think that's important to maintain. But at the same time, it's helpful to have international minimum standards.
Very good. So now let's try to focus on the NFT. So a few questions. So just take the example of countries that have partially considered approval of the DABUS. I think in English you say DABUS or DABUS, as an inventor of patents, such as Australia. Take an original NFT created by a human. Initial copyright would be granted to the human creator of the artwork behind the NFT. But the variants created by an AI, assuming that the AI does not belong to the same entity who created the NFT, okay, the artwork, would this fall into the ownership of the original NFT artwork creator, the AI as a creator, or the owner creator of the AI creating the derivatives of the NFT?
Okay, that's quite a complex question, which I really feel like I need to see it written down to follow. But I will say, firstly, AI being an inventor is not the same as AI being a creator, because the standard, the legal test for inventor in patents is not the same for the legal test for creativity in copyright. So we are seeing some countries refuse or accept AI as an inventor, but in patents, like just because someone's the inventor doesn't mean they're necessarily the beneficiary of the patent. So as I said before, like if you invent something in the course of your employment, it might be that the employer is the patent owner, but you count as the inventor. So I think that you just need to, it's a separate test. We're not seeing in copyright the same kind of thing. In copyright, I mentioned where Warner signed Endel, that's the headline. Like they've signed an AI, but they haven't really. When you look at the contract and you look at the paperwork, it's human names of actual people. And registered copyright in countries where you register. In the UK, we don't register, but in America, for example, the registered owner of the copyright or the creator of this copyright in the songs that used AI to create are the engineers. That's who they decided to put. So we're not quite there yet with actually granting, or whether we ever will be, granting the AI any copyright. With NFTs, like we could do a whole nother presentation on this, but because the NFT, the law is not even clear on whether the NFT is, first of all, an infringement of the copyright to the thing that it's linking to, because the NFT is not the tangible, say if it was linked to a tangible object, like whether it actually infringes the rights of the rights holder in the beginning. I think it probably should be, but again, it's a new technology. We don't know whether the law actually applies there or not. Some people argue so strongly that NFT is something that can be protected by copyright. Some people equally as strongly completely disagree that it's something that applies to copyright. So the answer in a quick answer is we don't know. And this is a really kind of emerging area where copyright's being pushed to its limits and tested. And again, it's down to the stakeholders arguing the different sides and then legally making a decision about whether it applies or not.
Okay. Quick question. Recently, OpenAI unveiled DALL-E number 2. So I suppose that's okay. That's a license. You can create an image by describing it. If your words are original, is the resulting work copyrightable, and by whom?
Good question. So in the joint authorship test, the case that I mentioned earlier, where they set out the test in the UK, the court said that the copyright owner is not necessarily the person who holds the pen. So for instance, if I say you just did it like as a human kind of parallel. So you're telling me your ideas and I'm writing them down. We're probably joint authors if I am collaborating with you. But if I'm just your note taker, then we could argue about who is the copyright owner, because they're your ideas, but there's no copyright protection in an idea. It has to be written down in a tangible form for a copyright to protect, and I'm the one writing it down. So it's not that simple even with people. When you then apply it to the AI doing it, it's your idea and you're maybe expressing an original idea. And then you could argue that the AI is simply a tool that is taking your original idea and churning out relative content, and therefore you are the copyright holder. Likewise, you could argue that copyright doesn't protect ideas, only tangible written down ideas, and therefore the AI, or if we want to decide to grant AI or not. Or you could be joint authors.
Well, as usual, with you, Haley, we could continue for hours. I really appreciated the discussion, but now we are close to the hour and it is time to conclude. So thank you again very much for accepting to participate in this webinar, to share your knowledge, to answer so many questions. Your expertise is very valuable. So thank you also to all the attendees who have stayed until the end. We have received many questions regarding the recording of this webinar. As usual, the webinar is recorded. It will be available on the website from tomorrow. The presentation as well will be made available. And you will receive a short questionnaire just to share your views and opinions about this webinar. So please provide any ideas for the future webinars as well. And for now, I will say that we have many, many other questions, and I hope that we will have the chance to have you back, Haley, in a next webinar. Thank you very
Thank
much.
you. Thanks for having me.
Goodbye.